And we're off. Hey, Rebecca, how are you?
Good, Sean. How are you?
I am doing well. I want to thank you very much for doing this. You and I actually just met, I guess, 6 weeks ago, 8 weeks ago, but
About
you are
that.
actually helping me complete a trilogy on my Did You Know That channel. So big kudos and big thumbs up to you. And we'll talk to, let everybody know momentarily why you're here and what the trilogy is all about. But the first thing is I want to thank you again for doing this episode. And I want to thank everybody for tuning in. Welcome to Did You Know That? Question mark. The channel where I get to talk to interesting people about interesting and sometimes annoying topics. And this one will be a mixture of the two, depending on your point of view. If you are a returning member, thank you very much for your patronage. If you are new to the channel, there's a little button below with a bell that you can subscribe to the channel and get notified when new content goes up every Thursday morning. And if you like this episode or previous episodes, please hit the like button or leave a positive comment because it does help the channel. Just to reiterate who I am for those who've heard it before and to introduce myself for those who don't know, my name is Sean O'Rourke. And when I am not interviewing people, I am a cyber liability consultant for Combs and Company, which is an insurance brokerage firm headquartered in New York City. And Rebecca, why don't you tell the fine folks who you are and what you do?
Thanks, Sean. So Rebecca Rakoski, I'm the managing partner and co-founder of XPAN Law Partners, and we are a boutique domestic and international cybersecurity and data privacy law firm. So that may help people understand how this trilogy is going to play out.
That is very true. And we've had, in our brief time in knowing each other, we've already had a couple of really good conversations, which is why I wanted to bring you on the channel. So the trilogy is around cyber. And as everybody knows who watches the channel or just knows me in general, that used to be my life, is still kind of my life, even though I'm not taking care of the technology. But in terms of the channel here, I've interviewed Diane Reynolds about cyber regulations, both domestic and international. I've interviewed Judy Selby about cyber insurance. And now with Rebecca, we're actually going to move inside a company. And we're going to talk about what a company does to sort of protect themselves, not necessarily from a technology standpoint, but from Rebecca's point of view, a legal standpoint. And so to kick this fun conversation off, because all my cyber conversations are fun because we tend to scare the hell out of people.
It's a side effect.
Yeah, exactly. And it's an intended side effect to a certain extent.
Yes, you should be afraid. Not
Yeah,
to quote another trilogy, but
exactly. Be afraid, be very afraid.
Very afraid.
So, Rebecca, you've been doing this for a long time. Again, we've had conversations about this, but I want you to give the audience a sense, at least for the clients that you have and the companies that you've engaged with. Do the folks running the business side appreciate the dangers to both their technology and their business when it comes to their technology infrastructure?
So that's a great question. And I would say, I'm going to give you the typical lawyer answer. I know Sean loves when I do this, but it depends, right? I think on the business side, if they've experienced a cyber, I will say an event, there's obviously different levels. If it's a breach, that's a legal term of art. But let's just say they experience a cyber event. I think it makes them hyper aware of what's going on from a cybersecurity, data protection, data privacy perspective. If they have not experienced it, for the most part, I would say there is somewhat of a disconnect. And I know that the tech community is, always jumping up and down and screaming and, setting things off in the boardroom, like fireworks and things like that to get their attention on it. But I would say that it's a mixed bag. I have had some clients come to me and say, this is the thing that keeps me up at night. And I know we're not doing it well. And that's why you're here. And I give those people big kudos because a lot of times that is that more proactive CISO general counsel. Usually it tends to be like in the general counsel head of IT, because they're the ones who are, they see other companies experiencing distress, and it makes them concerned for their own.
So outside of actually experiencing the event, which is I'll be honest, even my worst enemy, I would be hesitant to put a bad cyber incident on them because the repercussions are so
maybe
extreme.
My worst enemy. But,
well, maybe, yeah.
They'd have to
you know
rank
what? Now
pretty
that you
high
say
on the
that,
enemy.
the
Yeah.
Italian side of me says, okay, yes, my worst enemy, maybe even a marginal enemy if they really annoy me.
Right.
But so for those who haven't experienced an event and give you pushback, how do you go about convincing them that this is an area that could actually put them out of business if the event is severe enough?
Right. So I like to use, it is fear, and I don't like to convince people just out of fear alone. But I think they should be afraid. There's a good reason to be afraid. But I like to use the L word, liability. And that's really what scares, I think it's what scares organizations the most, is the idea that they could get sued, they could be subject to fines. Now, some of them are like, that's what we have insurance for. But I always say you don't ram, I take it back to car insurance, right? If you're driving a car, how many times you get mad and you have mild road rage, or in my case, extreme road rage, when I'm also Italian. When you're driving, but I have car insurance, but that doesn't mean I ram the car in front of me that just cut me off, right? You don't do that. And when you're not paying attention to proactive cyber measures, that's what you're doing. You're ramming the car in front of you. So, but what I like to do is I like to take them down the road of, this is what happens, right? You have a data breach or a data event. And, not only are we dealing with the actual event itself, you're locked out of your systems, you don't have access to your data, or a large swath of personal data that is collected on your clients, customers, vendors, et cetera, has been compromised. And that's a huge problem right there. So that's issue number one. Issue number two comes in, do I have to report this? And if I do, who do I report it to? Well, depending on your state, you could be reporting it to attorney general's offices. If you're in a regulated industry, you could be reporting to New York Department of Financial Services, NYDFS. If you're subject to the DFS Cyber Reg 500, you could be reporting to the Office of Civil Rights for a HIPAA violation. If you're a healthcare organization or a business associate, you could be reporting up to the covered entity, and they're reporting up to the OCR. So, I mean, there's a lot of reporting. But from that, I always like to say, and I'm actually in the process of writing an article called "It's not the breach, but it's the shrapnel that will get you," right? Because
I like that.
Right, I thought that was kind of cute.
That's good.
But it's appropriate, right? Because it's not the breach itself is horrible, and 6 ways to Sunday, you are sucked into a vortex of problems right there. Yep. But once that's resolved, now you have the regulatory aspect of it. You have regulators coming in. Speaking of DFS, the Department of Financial Services just issued a $3 million fine.
Right.
I think you posted it, and
I did.
I'm one of those crazy people who read that stuff when I liked it.
I read it too. So I've joined your club.
Right. Join my club. It's fun. It's also the cure for insomnia for those of you who can't sleep like me. But I read it and I was thinking to myself, and that's kind of the impetus. So thank you for me thinking of this article, because I'm thinking to myself, if you're looking at this consent order for this organization that's getting, not only are you getting the $3 million fine, horrible liability, there you go. You're also going to have the added bonus of being monitored by DFS for a period of time, because it had a series of things that they have to do. It also puts you on their radar. So now they're thinking you're already not doing something well. We're going to come back at you and keep looking at you. And in addition to that, now you have the third prong of liability, which is the information that was compromised. Those people are coming out. And I read another article about a rise in privacy class action lawsuits.
Oh, absolutely. Yep.
And, if that's not the newest, people thought that plaintiffs' attorneys were hungry before. I mean, this is a treasure trove of lawsuits that are being opened up here. But so that's how I really talk to them, because they understand. And if if that doesn't work, I always say to them, well, let's look at what your regulatory fine would be if you were breached today. Okay. If we're looking at GDPR, if we're looking at the General Data Protection Regulation out of Europe, if you're looking at the California Consumer Privacy Act, the CCPA out of California, if you're looking at the fines issued by DFS or Office of Civil Rights for HIPAA, let's look at that and think about what is your exposure. And that really tends to make them stop for a moment and really realize that the investment in proactive security and privacy measures is far less, and you get a bigger return on investment than you do if you just pull a ostrich and stick your head in the sand.
Right, exactly. I'm glad you used that bird, because that's always my thing.
Yeah.
You can't.
Don't be an ostrich.
Right. Well, and as everybody knows, I always have questions, and here are my questions, that the prompt questions that I gave you, but we're already about to go
we're veering
on
off.
a bit of a tangent, because I'm glad you did bring up the DFS fine.
Yeah.
Because what really struck me, and we'll circle this back to the insurance piece as well, but the consent, I believe there was only 3 or 4 violations that they consented to.
Right.
But when you look at the number, so that's either $750,000 or $1 million per violation. The only way the only place that number is going to go is up, because the state of New York is going to look at this and say, hey, if we start catching all these people and we could get $1 million a violation or $1.5 million a violation. I mean, it's like the Office of Civil Rights every year since I think 2013 has been a record year in terms of the fines issued by the Office of Civil Rights.
Yeah.
This is a revenue generation
huge
avenue for states.
Yes. And once you get hit once, they're coming back, because they're like, oh, you're a serial violator.
Right.
So we can come in every single time we come in to look at you. I always say, they're going to find something.
Yes.
Once they start digging in there, they're going to they're looking for something. So if your program isn't, batten down the hatches,
right.
those things are not nailed down, you're in big trouble.
Yeah. So, and the other thing that I noticed about the consent, and we'll swing this back to insurance, because I don't know what insurance the company had. It's I think it was a mortgage company or something along those lines. But one of them was they didn't report it when they should have reported it. And I forget what the other one was, but I read it, and in reading it, if I was an insurance carrier who got a claim for the regulatory fine to sort of cover that, I would read that and say, well, you were kind of willful in not following the law. So if you read your policy, willful acts are not covered.
Right.
And the resulting fine, I'm going to argue as an insurance carrier, is not covered.
Well, it's interesting you bring up the issue with insurance, because I was reading a case out of the Ninth Circuit where insurance denied coverage.
Yep.
Based on, it wasn't based on the fines that were issued, but it was based on the fact that they said that a demand had not actually been made.
Right.
It was a situation where they're like, well, we're just not, there had been a monetary transfer, which happens more times than than I can even count. And they said the party that had been the victim of the fraud said, well, we're just not going to pay you until we recoup that money. So it wasn't a claim, and the court agreed with it. And basically they said, no, insurance doesn't cover it. So you're going to start to find this happening more and more with insurance coverage. And by all means, I encourage all my clients to have standalone cyber coverage, as you're not, when we've had this conversation.
Sure.
But if you're not doing everything you're supposed to be doing, and in this situation, it was also that they hadn't, they were supposed to have turned on multi-factor authentication.
Oh yeah, that was the other thing. Done
it right. They hadn't fully accomplished that, right. And it was like a year or something had gone by. And like, it's one thing to say like, all right, this is part of our plan and this is what we're doing, but they hadn't fully, what I would say, they hadn't fully operationalized that part of their, they had already gotten slapped once. right?
Right. And the other thing is that for those of you who don't know, with the Department of Financial Services, every company that is under their purview has to file an annual filing. Combs and Company has to file an annual filing certifying that you're complying with the elements of the regulation to which you are subject. Because there are 16 elements, 9 of them are required, 7 of them you can be exempt from given your size and what have you. But this company was not exempt from any of them. So they had to follow all 16, and they kept filing the paperwork to say, yep, we're in compliant. And then they go and they find out that they're not. And one of the very simple ones is multi-factor authentication. I mean, that is free in a lot of elements. And all you have to do is click a button and turn it on.
I was shocked because I was like, I think their argument was, well, we were moving from Microsoft to Google. And I'm like, yeah, but you can still get it. It's not like it's not available. It's not like Microsoft is like, we don't believe in multi-factor. You can get it through Microsoft, just like you can get it through Google. So yeah, it was somewhat shocking. And I think that was the third, that was the third thing, wasn't it? That they had certified.
I think those were the 3 of them. Yeah.
See, between the 2 of us, we remember the whole article.
There we go. Actually, I could probably bring it up and share the screen, and we can just read through it.
Right.
Everybody will go to sleep, and it'll be a great episode. And
I mean, I thought it was fascinating because I was just like, this is exactly stuff that we talk about. That you know, we say we're doing something, we're not doing. We think we're doing something, we're doing it, but we're not really doing it. Somebody certifies, and bam, that's the shrapnel. That's the shrapnel I'm talking about.
Well, and then this is perfect segue actually back to my questions. So let's say they're your client, and let's say this is back in 2016 to 17 when Part 500 was just passed and is about to go live. You have that sort of year lag time before they start enforcing it in 18 and whatnot. What are you doing with your client? Let's say that they were your client. And again, I forget the name of the company. It just escapes me. But let's say that was your client. What are you doing with them? And we'll use DFS if you want, or you could just use whatever process that you use. But what are you doing with them on a regular basis to sort of get their cyber house in order?
I'm nagging them. I'm really good at it.
You are a mom. You are a mom.
I am. So no, I mean, I'm staying on top of it. When I work with clients, and this is across the board. Now I work with startups and I work with fully, mature organizations, from small little guys all the way up to multinational corporations, and, with varying degrees of what they need me to do. But if I'm working on their security, the first thing that I do is I do an assessment. I'm like, what laws are we triggering here? Because the information is all, what you need to do is in your data. Some people are just not paying attention to it, right?
Sure.
So, you have contracts. I've had clients who say, oh, we're not HIPAA. We don't deal with HIPAA. And I find business associate agreements that they've signed. And I'm like, you do realize you've contractually obligated yourself to comply with HIPAA. We did? Yes. And so the first thing to do is assess the situation. If you don't know, you assess, right?
Yeah.
So I go in, I look at your data, I look at what you're collecting, and I go, okay, here are the laws that based on your data collection practices, these are the laws that you're triggering. Okay. Now we know what field we're playing on. Okay. And so most times you're dealing with multiple regulations, right?
Yeah. And then things really get fun.
Then it gets super fun. Yeah. The second step is based on the assessment, I provide this roadmap and I go, okay, what do we need to comply with? How are we going to meet our obligations? And then we start from that roadmap, we create what I would call an implementation plan. So I take them through and I'm like, this is how we're going to fix these issues. The reason I like to do that, and I do it, I'm an attorney, obviously, is because some of the decisions we're making are not necessarily business decisions, they're legal liability decisions. So, hey, we need opt-in for one law and opt-out for another, but we're not, so we're going to be talking about that. Part of that is a business decision, but most of that is a legal determination. Like this is the legality of it, and then how are we going to comply? So that's another thing is having that roadmap in place. Now, this company that we're talking about for DFS, it sounds like they had a roadmap, right? So they still got dunked. The question
claim
is,
they had a
they
roadmap.
claim they had a roadmap.
Right.
But, I tend to see, and my experience has been that when you can show that you're moving towards that goal, that the regulators are less likely to, what I would call, punish you, right? They're less
Mhm.
likely to slap you down. They're going to like, okay, well, we see you're trying to accomplish good practices, so let's give you that opportunity. Let's not, slap you down too hard with a big fine and a big, monitoring. But, here, and then I tick off the easy things. So 2FA, multi-factor, that's one of
Yeah.
the first things we hit. Like,
Yeah.
why are we messing around?
Yep.
It's not infallible, but it's like, it's as close to as you're going to get. There's no perfect thing in this space, but that's one of the things that's simple, cheap, easy. Why are we not using it? There's no reason we're turning it on. There's a lot of groaning and moaning from upper management, and
I don't want to have to do it.
I don't
Yeah.
care. I'm like,
And it's
yep,
always upper management.
Yeah.
It's never regular employees. It's
No.
always upper management.
And usually the best answer is because our lawyer told us to, and they shut up. They're like, oh, I'm sorry. The lawyer said, oh, okay.
Okay.
Well,
Yep.
that way. When their tech guy has been saying this for 10 years.
Right.
But as soon as the lawyer says it, they're like, oh God, and I'm like, fine. If I need to be the mouthpiece, I'm happy to do it.
Sure.
And you can have your little, voodoo dolls with pins with my image sticking me with pins, and I don't care. But so those are the things we tick off the easy. Let's get the stuff that we can get done quickly. Let's get that done.
Yeah.
Right. We're not going to mess around. We're going to move. We're going to push. We're going to move forward. I mean, I'm working with a lot of corporations on this very thing right now, organizations, and we're just every single month we're moving forward. Here's the step. This is what I have, like big pie graphs and charts and showing our progress, because we want to see and we want to be able to measure that progress. But the easy stuff should be done. The fact that company didn't have 2FA turned on is just. And all these laws give you this runway too. They're like, we're going to give you a year. So why not get that easy stuff done? You've got a year to get it done.
So quick tangent. The one thing that I did notice is that the part of these provisions require you to have a CISO, a Chief Information Security Officer. And that CISO is the one responsible for signing off on the certification. They did not single out the CISO.
Yeah.
They did not call out the CISO. They did not, there was no fine for false certification by the CISO. So they didn't ding the CISO, which is very different than what happened to Uber's CISO
right
after their hack. And he was prosecuted or is being prosecuted. I'm not sure where that stands. So that was interesting to me that they didn't do that, considering the CISO had to sign off on it.
Yeah.
On each of the certifications. But to your point, that for a CISO, that should have been a no-brainer. And
I'm wondering if the reason the CISO wasn't dinged was because they may have been pushing and getting pushed back. And when you're only one voice, it's hard to force the issue. And the other issue is, and one of the reasons why I like things like GDPR, and I know people criticize, they're like, oh, GDPR. But one of the great things about that is the designated privacy officer or the chief privacy officer under GDPR is supposed to be quasi, or not really quasi, but autonomous, and be able to make recommendations. And those recommendations need to be followed by the organization, because they're supposed to be the person who has the most knowledge with regard to the, obviously with privacy and things like that.
Sure.
But I think that's interesting. And I think the problem with CISOs and the problem you see over and over again, and I have some sympathy for them, a lot of sympathy for them, because they're the ones who always get fired. They're the ones that always get prosecuted. They're everybody's jerk. They don't have that autonomy. They're working within the construct of the company, and they're reporting up as the chief information security officer. But having a little bit more, maybe creating roles where that autonomy exists a little bit more, will be helpful. And they're in that constant situation of, what do I do? I have I have this bottom line, but then I have to do the security, and that tension, I think, is unfortunate, but a reality of what we're dealing with. So
I want to get back to what you do internally, because One of the things that you mentioned was the business associates agreements. And for
Mhm.
those who aren't familiar with HIPAA, basically it's a third party organization dealing with somebody who's under HIPAA requirements, that you will also follow the requirements of HIPAA when it comes to your technology and data in order to do business with that other party.
Mhm.
Do your clients have a tendency to sign those blindly or other agreements blindly? Or do they send them to you first, say, hey, what am I signing and what am I agreeing to? And then at least they're educated in what they're putting their signature on. Or is it just, well, I'm signing it and I'll deal with it later?
No, my clients get to tell them that because we have a, I'm very fortunate. I work with a lot of great organizations and I have a great relationship with either their general counsel or their outside general counsel, with their in-house IT departments. I think it's funny because at the beginning, I thought that the closer relationships I would have would be with general counsel, but it ends up being with IT because general counsel, they're great, but they're dealing with business issues and 50 million other issues, and they don't have the time to become the fully knowledgeable attorney on privacy and security issues. So that's where I come in. I like to say we're like the SEAL team, right? We come in, we help you out with a very particular issue, and then we get out. But for the most part, that getting out part doesn't work. I end up staying for a while and helping out, which
I mean,
makes
technology
sense.
isn't going anywhere,
It's
so
not.
neither
It's
are
not.
you.
So I guess I should probably rethink that SEAL team analogy. But anyway, my point is that the companies that I work with regularly don't sign anything. I negotiate their tech contracts. They're not signing business associate agreements because they are well informed that we don't sign them unless we have to. And I find that organizations, covered entities, so that's the direct, like that's your provider, that's what you're talking about, right? The covered entities pass out BAAs like it's PEZ.
Yeah.
And I'm like,
excellent candy reference, by the way.
right, thank you. I love, who doesn't love PEZ?
Yeah.
Eating the whole slide in one sitting. So, you used to, but they give them to everybody. And I'm like, but you're not collecting health information. Why am I getting a business associate?
Sure.
And so my clients tend to push back. I like to think that's my influence. In fact, I do think it's my influence on them. And then we negotiate all the contracts. Now, a lot of these clients where I'm mentioning, they have business associates that I'm discovering that as I'm doing an assessment and I'm reviewing their documents. So that's how that kind of comes up. But yeah, I review everything, anything technology, anything involving data. So as you can imagine, unless we're talking about the lawn mowing contract, I'm pretty much involved in all of their contracts. And I don't negotiate the price terms and things like that. I'm negotiating the privacy and security specific provisions and making sure it's consistent throughout, because sometimes people like just slap in something and they're like, well, this is good enough. And I'm like, yeah, but now it conflicts with another provision. So you read it holistically, but the parts that I deal with are mostly the security and privacy.
Okay. So then let's talk about this. Your client decides they want to go from, let's say, in-house technology. They want to go as much cloud as possible.
Right.
Let's just use Microsoft Office 365 or Google's G Suite or what have you. There are terms and conditions that come with those.
There are.
Those are pretty much non-negotiable for most entities. What do you do in that kind of situation for your client?
So there's two ways to deal with it. Well, really one way. And I will say this, that there are courts, I have been reading opinions more and more lately, where cloud service providers are getting dinged because courts are saying these are contracts of adhesion. If you can't negotiate a contract, if you're taking no responsibility on yourself, then it's inherently unfair. And so we're not going to put all of the onus on the customer or the client. So we are seeing that, and I think you're going to see more of that. You're going to see more courts looking at it in that regard, because I think that's, frankly, that's the way they should be looking at it. But where we are stuck with right now, it is fair.
Yeah.
It's a shared responsibility model, right?
Yes.
And the point is, having that shared responsibility makes everybody have that skin in the game, encourages everybody's good behavior. And so I think that's, it's important, but because you can't negotiate those contracts right now. What we do is we look at either spreading out the liability, right? So we may be assuming certain liability through the cloud service provider, but we may be pushing it through different vendors and things like that, so that you can spread the liability through different contractual provisions. And then you shore it up with insurance, because you don't want to be assuming all of the risks internally. So having comprehensive cyber liability insurance, and frankly, it's another thing I look at with my clients is, what is your insurance policy? Are we really insuring for your data collection practices? And that's important, because if you're not, you have to have the proper insurance that fits with what you're doing. So it's the right key in the lock. Otherwise,
And we're going to talk about insurance in just a little bit, because even though I had an entire episode about cyber insurance, I wanted to get your take on it, because what I'm seeing is, I'm not surprised by it, but it does concern me in terms of my clients. And so we'll get to talk about that. So let's say a Microsoft or a Google third-party contract, or terms and conditions and whatnot, to use their cloud providers. To use their cloud services.
Right.
Are you essentially giving your clients the heads up that, hey, look, while this is heavily weighted in the favor of the cloud provider, here's where you're going to be responsible, and you need to focus, versus here's where the cloud provider is going to take responsibility for X, Y, and Z? Are you giving your clients sort of that kind of minutia, or is it just a high level, okay, go ahead and sign, or what have you?
It depends on what they're looking for from me and my level of involvement. For clients where I would say I'm probably not technically, but by default, they're outside privacy and security counsel. Like I review everything that comes across their desks. I'm looking at all that, right? I'm that person. I track all of their contracts. I think it's good because I keep copies of their contracts separately. That way, if their system is ever compromised, we have separate contracts of it. But I also have all of the privacy and security obligations of the provider and of my client tracked, so that they know exactly what those obligations are. But the other thing is, where I can't, when I work with my clients, we're going to shore up their systems as much as we possibly can. So regardless of what's going on the cloud side, and there are, obviously there's benefits and detractors from using a cloud and not an in-house server. And there's benefits and detractors from using an in-house server. Nothing is perfect. What you're doing is you're talking about risk mitigation and what makes the most sense for the organization and their business model, and where they want to go. And that's something that my firm, we take into heavy consideration. It's not a one-size-fits-all situation. So it's really particularized, and we work very heavily with the business aspect of it to make sure that it's what we're doing from a technology and a legal perspective is complementing the business and where it wants to go, because it should work organically together. But when we're going to be shoring up on our side, on the client side, all of the security, privacy issues that could pop up. So, and making sure that it's documented for, in the unfortunate but all too likely event of a data incident, that they have the appropriate, they're ready to execute on their breach response plan. They know exactly where everything's located. They've crossed their T's and dotted their I's in terms of compliance. So we know we're going to know exactly what we've done in order to create the most secure environment we can, with the idea that it's never secure.
Well, and
that makes sense. I hope that.
Oh yeah, no, it
okay.
makes perfect sense to me in terms of what we're going to try to do is get the viewership. If it does make sense to you, be sure to ping one of us for further explanation, or put some comments or questions down in the chat below, and we'll respond to them. So in this regard, in terms of writing agreements for your clients that have sort of cyber provisions, because there's either going to be access to systems, or there's going to be access to data, and or other sorts of those gray areas of technology where
intellectual
all of a
property.
sudden,
I mean, there's a lot of stuff in a system beyond just personal data.
Right. And there's a lot of gray area in terms of how these relationships eventually evolve, because all of a sudden, well, this way's not working, so let's just jury rig this to make sure it happens and whatnot. What are you focusing on to limit the exposure or the liability, in, to use your word, for your client, to make sure that they're as protected as possible in these types of agreements?
So I have some, the language that I use is usually pretty restrictive to begin with. I try, especially with vendors, right? Like we're not just talking about cloud service providers, so that would be the vendor, I would say vertically.
Yeah.
But then horizontally, what are my clients' vendors? And so all of those are going to have contracts as well. If you're not negotiating the vertical, you're going to negotiate the horizontal. And so in that regard, I put in very restrictive privacy and security provisions, because in most cases, then my client is, to use a GDPR type phrase, is the controller. But in some instances, in some data transactions.
Let me stop you real quick.
Yep.
Restrictive for who? Your client?
For them. For the vendor. Okay. Yeah. For the third party, not necessarily for your client, but for the vendor who they're partnering with, for lack of a better term. I mean, I'm going to put the most flexibility for my client and the least flexibility for my adversary, right? That's the goal, right? Yep. Protect the castle, although I hate that expression because there is no castle and there's no perimeter and all that other stuff, but for analogous purposes, you protect the castle as much as you can, and I push the liability everywhere else. But not just liability. I want to make sure, and this is something in DFS, in HIPAA, GDPR, CCP, pick a reg, right? Any reg. Right. You're going to be dealing with vendors and vendor agreements, and making sure those vendor agreements are accurate. In other words, not signing the business associate agreement if you don't have to, and things like that. Understanding what role you're playing in that data transaction. Am I really the controller? Am I the processor more? And then from there, what you want to do is make sure that those agreements line up with that, and that I always make sure that my clients have the ability to audit, for example, whether or not they choose to exercise that ability or not. And I put in regularly auditing provisions, particularly when you do have something that's a vendor that's collecting a lot of data. You want to be able to go in there and get a copy of their SOC 2. You want to be able to say, like, what standard are you following? And I always find it very helpful, because when you start to negotiate the contract, and I go, okay, so what standard do you follow? Because we're going to put that right in the contract. So that way I know if you're following ISO 27, you may not be ISO certified, ISO 27001, but at least I know that's your North Star, right? And from there, I can say, do you have these controls locked off? If there's a problem, now I have a standard to follow. Okay. HIPAA is easy because you're following a HIPAA standard. Do you follow NIST cybersecurity framework? Do you follow their privacy framework? But having that kind of structure within a contract, and not just data. Okay. That's not helpful. And it's not helpful on the other end. If there's a data breach or a problem, having something that I can point to and go, okay, well, you said you were following NIST cyber framework, so let's start looking at this. Do you use a NIST standard of encryption? Do you where are
you have a baseline off which to work,
right?
And so if anything does go wrong, you can at least start there.
Exactly, and they have a baseline too. I mean, now they've signed a contract. Whether they appreciate what that means or not that's not on me. That's on them. But when I go in there and I do an audit for my clients, and I say, let me take a look. Let me see your SOC 2. Let me see your thing. Let me see your policies and standards. Let me see. And they can't prove it. Now, all of a sudden, I'm going, we're dancing dangerously close to breach of contract. Because you told me that you were following this standard, and you're clearly not.
Well, I was following it in my head. I just hadn't written it down yet.
Right.
But it was in my head. It was in my head.
So.
Well, I mean, if nothing else, if people what people watching this episode have learned nothing else is that you need an attorney who's experienced in cyber.
Yeah.
You cannot go, there's all sorts of specialized attorneys, and then there's general business attorneys and what have you. That's not who you need to go to on this stuff. You need to go to people like Rebecca and like some other attorneys I've interviewed, because that's your area of expertise, is on the cyber. And the cyber world is very complex because you need to be comfortable with the technology and the law. Mm-hmm. Not either or. You need to be comfortable with both of them.
Yeah. And I mean, I appreciate you saying that, because I see a lot of people who are like, well, I'll just figure it out as I go along. I'm like, you do not want to be figuring this out as you go along. Like, the fact, I mean, we're talking about like articles we've read and standards that I sat down the other day and I'm like going through the proposed New York Privacy Act, looking at all the things. I know, right? Nobody likes the law. I like it. But
you're a lawyer.
I know, I like laws. You want to know why? Laws are rule books. Rule books you can follow.
At least you have something. That's the point. Yes. I give you that. At least you have something.
And what I don't want is this patchwork that we're developing, which doesn't seem to be going away, and which an enormous headache.
Which makes you even more important. But because you're creating a quilt. Yeah. It's an ugly quilt, but you're creating a quilt.
Hideously ugly quilt. Yes. I feel bad for organizations because they feel like they're playing whack-a-mole with laws, and they are. Yeah. And it's like, well, where are we going today? Yeah. But I'm a big proponent of a federal law. I know some people are like, oh, regulation.
Oh no, we need just for the sake of some sanity.
Yeah.
Yes, I get it. Yep. So, I agree with you, because I'm not one for federal regulations just for the sake of federal regulations. But in this instance, it's insane. You cannot run a business.
And data breach, I mean, look at just the data breach notification laws. Yeah. I'm a adjunct professor and I teach cybersecurity law, and we were going through the state laws, and I just picked 5 randomly and I compared them, and the students were like, oh my God. And that's just 5. I picked like fun states. I'm like, let's look at Hawaii and Florida and New York. And, I tried to kind of see, and I just randomly picked them, I was like, I'm just going to pick random ones just for fun. And they're just shocked. And that's what's happening in privacy too. And it's just.
And that's just the general, I'm sure that was just the general data breach notification. So it was none of the other specific things that we had talked about so far in this episode.
Right. So we're not dealing with HIPAA or DFS or CCPA, none of that. This is just straight data breach notification law. And it's complicated. And so, I do.
And almost all business is interstate business now.
Oh God, yeah.
If you're online, almost all business is interstate business.
I tried to get a hashtag going online, data has no borders, but it didn't take off.
Oh, I'll pick it up. I'll start using it. I'll give you props for it. Data has no borders. I like that.
Because it's, you have laws and regulations that have borders, but that data is moving back and forth all the time. And I mean, you're in New York, I'm in New Jersey. But data's going back and forth, New York, New Jersey. I mean, and it's not just the states where there tends to be a lot of people and a lot of business. It goes all over the place. So, and internationally, it starts to become, it's literally a spider web, or a friend of mine called it a constellation of data. I like that.
Oh, I like that.
I know, right?
And so your job is to organize all those disparate stars into something that makes sense, like Orion or the Big Dipper.
Bringing order to the chaos.
Right. I like that. Well, there's your other hashtag, bringing order to the chaos.
To the chaos.
So let's talk about insurance real quick, because we're at 40 minutes. We still got time. You and I could go all day on this.
I know, right?
I don't think people will watch us all day, even though we are amusing.
We are.
So I'm seeing what I expected to see is a hardening of cyber insurance. And in some instances, the reduction in coverage. I won't name the carrier, but there is one carrier that caught me off guard, because they've begun to pretty much package cyber with any of their professional liability slash E&O insurance, except it's a bastardized version of cyber. They pull out a lot of the really important, what I think are the really important coverage provisions, and they've dropped the limits, significantly dropped the limits. And that surprised me because one of my clients renewed, and I wasn't really involved in the renewal. The account executive was, and she thought this was going to be a better deal because it was a whole package as opposed to having disparate carriers. And it wasn't until a couple months later that I sort of had a moment to read through the renewal. I was like, holy crap, you guys can't work with this. So I've had to go back to them and say, okay, we got to get you a standalone policy from someone else if we can't get it from this carrier.
Right.
Are you seeing that yourself? And what are you seeing that heartens you on cyber insurance and then sort of makes you nervous in terms of liability? Again, there's that word again.
I like the L word. Not for my clients though. So yeah, I mean, what I'm seeing, and I mean, I talk with not just, brokers, but I talk with in-house, cyber, insurance carriers. Like I talk with their in-house counsel. I'm on panels with them and stuff like that. And I'm always asking them, what are you seeing?
Right.
Because I'm not a panel counsel myself. So I work with companies who don't have insurance. And then as soon as it's done, I'm like, quick, let's go. We got to get insurance. We're getting insurance now. But what I'm seeing is, because I review a lot of my clients' cyber policies. And what I'm hearing in the industry is exactly what you said, a hardening of the policies. They're constricting them. They're much more expensive. They used to be cheap to get cyber liability insurance. And now it's very expensive. Insurance companies are saying it's just, we're paying out left and right. And so, this reminds me a lot of, and I'm going to age myself here, what happened in the 1980s and the 1990s with personal injury. And
yes,
what you
that's
saw
a good
with that.
analogy.
Yeah. I mean, people had these insurance policies and they were paying out on left and right. And eventually what happened was, they did all kinds of, tort reform. I air quote that because I'm not a huge fan of tort reform, but be that as it may, that's what they did. And it made it more difficult to bring a lawsuit. Insurance carriers were more likely to do denial of coverage if there were issues. And I think that's what we're going to see here. And that's the kind of the grumbling I hear. I haven't had that happen to one of my clients yet, but as I'm reading opinions where, it was basically a denial of coverage and they were unable to recoup that money. The company was unable to recoup the money. And so, that's what's happening. And I think we're going to see that more and more because of the, what we're experiencing with data breaches. And I think you're going to see a big increase in cyber policies, which is, monetarily for their premiums, which is scary because businesses all need them. They need it.
Right.
It's so expensive. And the other thing was interesting. I was speaking with somebody at an insurance company who I will not name names there, but they were telling me that they have no way to really accurately identify what it's going to cost a cyber breach.
Absolutely not.
It's like they close their eyes and they pull and they go, that's it. Because in one breach, it's the notification. In another breach, it's the PR. And it's every single data breach is like a snowflake, right? It's totally different. You can have some of the very similar, but it always goes differently than everything else. So I think that I also think you're going to see a lot more subrogation cases coming out of that. And
can you explain what subrogation is real quick?
Yeah.
Because I think that's an interesting point, but I want everybody to understand it in sort of layman's terms. So
subrogation is if my firm has insurance and the data breach comes from one of my vendors or something happens and it's not very clear about how it all works. My insurance company will pay my premium, will pay me out, right? Will pay out for the data breach.
Your claim,
Their claim, right? Something. And then they will turn around and they will sue the vendor. So that's a subrogation. They're going to try to recoup the cost, what they've paid out in the claim to me, by suing the vendor, basically. So more business
But
to
it
business
removes you from the equation because you
Correct.
can't sue your vendor then.
I cannot in
Right.
that situation, right? So I think that's what you're going to be seeing a lot more of, more declaratory judgment actions or deck suits where they're trying to figure out, or coverage lawsuits where we're like, well, which insurance company is going to pay and how much? Because the way it's structured now, it's usually the breached entity, regardless of
Right.
where it came from, their insurance is paying out, right? And so seeing how it's going to kind of trickle down, because again, I'll go back to like something we all can visualize is a multi-car accident, right? You're at a stoplight, you stop, and then the car behind you hits you and you pushes you into the next car, and then it's like, which insurance
Chain reaction.
right?
Yeah.
Who's going to sue, and how is that going to sue? So I think that's what we're going to be seeing more of that.
But it's interesting because that chain reaction that you just talked about actually started from a car that you can't identify in some cases, or
Right.
can't gain access to.
Right.
The person driving that car,
Mm-hmm.
because they actually did it virtually.
Right.
So they caused a massive pileup from 15,000 miles away,
Yeah.
and the insurance carrier can't get to them. They can't sue them.
Right.
Interpol, CIA, FBI, NSA, whoever you want to say from a law enforcement standpoint, can't get to them.
Right.
So now all of a sudden, the actual cause of the wreck is inaccessible.
Gone.
So, but the insurance carrier needs to go after somebody.
Right.
And now you start to get into these gray areas, because the scenario that I came up with was involves either AWS from Amazon
Mm-hmm.
or Microsoft's Azure platform, or even to a lesser extent, Google's cloud.
Mm-hmm.
Google's cloud is not as popular as those other two are at the moment. But what if they were hacked across the broad spectrum of their platform?
Right. And for those people who are out there going, that'll never happen, they also never thought Equifax would happen. They
Right.
never thought SolarWinds would happen.
If you can envision it,
happen.
it can happen.
And it's going to.
And it will happen.
It will happen. There's no
Yes.
doubt in my mind we will have that. I'm not saying tomorrow, but it's going to happen. So I'm sorry, go ahead.
But no. But that's the thing. I mean, you and I talked about it. It's not a matter of if, it's when. All you need is enough time, and everything is going to happen. But then my thinking is the chaos that would be created by that, because you would have the entities that use the cloud platform.
Mm-hmm.
So let's say a New York State financial services firm who's using AWS, it gets hacked. The information that entity controls, and again, I put it in air quotes because it's a shared control. DFS is going to go after the covered entity, not Amazon.
Right.
That entity is going to submit to their insurance carrier to get paid. The insurance carrier is going to say, well, wait a second, it was Amazon that got hit. Why am I paying you when it's Amazon that get hit? And make Amazon pay. And Amazon's going to say, well, look, limitation of liability, I'll pay what I'm liable for, but it's not all that. And then you also have plaintiffs' attorneys who are going to come knocking on the door. Hey, my client's information was part of that hack.
Right.
I'm going to knock on the door. If Amazon and the user of that vendor, I mean, the chaos in that would be
massive class action.
Incalculable almost.
Yes. And that's why, I think about this kind of stuff all the time. I literally had like a nightmare about it the other day where I was like my phone got hacked and it just started calling random people. It was like literally my dream.
Right.
And somebody in my dream was like, shut it down, shut it off. And I'm like, but I woke up in a panic because this is the kind of, this is the world we live in. And so, and this is, if it scares me, I don't understand how it doesn't scare everybody. I don't get it, but it is.
By the way, ostrich. That's why it doesn't scare everybody.
I know.
Ostriches.
Until it happens to them,
Yes,
until it happens to them. And unfortunately that's, it's, as we said, everyone is going to experience this in one way, shape or form. But yeah, I mean, that kind of, it almost reminds me of the financial crash of 2008. It took that massive breakdown in order to do reforms, right?
Right.
And so I think that's, when it happens to Amazon, when it happens to, whatever, then that's when we'll see real movement in this area, because it will be so big that there's no other way. And I also just want to say the other problem is we are taking traditional areas of the law, right? And we're jamming them into something that's not traditional, right? We've never experienced this in our lifetime. And it's not this type of data proliferation and use of data and data exchange. This is completely different. The Pony Express did not contemplate this type of data exchange. And so when you think about it, I think that really we're going to have to start to think about it in different terms, not just breach of contract and negligence and gross negligence. And, but we're going to have to start, and I don't know what that is. When I come up with it, I will let you know. But
we'll do part two.
Right, part two. But that's what I think is the problem, is that we are trying to jam a non-traditional practice into what we have always held in terms of liability, and it doesn't fit nicely.
I've had this very conversation with multiple cyber attorneys, and I've actually come to my own conclusion, and I say this is just me. I don't think it's humanly possible to address this situation. Because if you think about it, think of the scenario we just presented in just a minute or two, but then the almost innumerable threads that would be pulled by such an event, given the interconnectivity of data systems and what have you, is that I think it's beyond the human capability to sit down and discover and envision all those threads that get pulled and be able to address or create something that would address those.
Yeah.
That's why I think the national privacy and data rule, well, I think you can learn from GDPR, but do better.
And why not? Why wouldn't you improve on it?
Right. Because you've had enough time to figure out, okay, this works, this doesn't work, we can do this instead of this. But I think that's as far as we're going to be able to go. And then everything else is going to be trial and error, because I just don't think you could sit down and realistically come up with that. Because the nightmare scenario of just getting your phone hacked, I mean, there's just so much in that by itself, and you're one person.
Yeah. But I mean, think about it. If you are, and I was speaking to a colleague of mine the other day, who is the head of a big organization in New Jersey. And he said, in 20 years, we're going to look back at this time and be like, what the heck were we doing? Like, you know what I mean? He said, he's like, it's like we walk around with loaded guns and shoot people. He goes, that's how we treat security in this country. Like we're literally walking around with loaded guns in our pocket, because that's what, and I don't mean to this isn't political about gun control. But that's what we have. The gun is the data, the information we have on each other. He said, we walk around with loaded guns and shoot people on the street. He goes, and nothing happens. He's like, in 20 years, we're going to look back at this and go, what? Are you kidding? Like, why were we doing that? It's so stupid. He said, there's ways to control this and ways to monitor this, and we're not doing them in the interest of giving big tech their reign. We're letting them run.
Yeah, well, that could be part 3.
There we go.
There's a lot to unload when it comes to big tech and what have you, because it's not just big tech, it's government, it's
the whole thing. It's
individual hacker organizations, whether they're white, gray, or black. I mean, people don't realize, and I think that might be one of the reasons why we think people should be scared and they don't get scared, is because we're so close to this. We kind of know really the chaos that's going on, or the potential.
I wake up in the middle of the night with a heart palpitation of my nightmare scenario.
Well, and I tell people this, I've watched The Social Dilemma was good just because I think it broached the topic of social media and what they're doing to try to create addicts, addictive users out of it. But there have been other documentaries recently that are cyber based or their exposés. And I'm like, dude, that's like 8 years old. We've already been through this. We're well beyond that.
So beyond it. Yep.
But the one episode that I watched recently that really made me nervous, because to your point, it made me think of the potential impact, was the New York Times has a show on FX, I think, called New York Times Presents.
Mm-hmm.
And this one was about the teenager that hacked Twitter. And so you remember the big Twitter hack where they were selling the Bitcoin, send me 1,000 and I'll send you 2,000 back. And they hacked all the big name accounts and what have you. Well, it was a 15-year-old kid and a 17-year-old kid that pulled off this hack. But what they did and what they posited, and it's, I thought about it after the fact, and I really thought, wow, that could have been different. That could have been really bad. Is that what if these kids had actually had been in the stock market and decided to manipulate it by saying Russia has a nuclear accident, or Russia drops a nuclear bomb on Ukraine, or Germany has entered the Ukraine, Western Ukraine, or the United States, there was another sort of 3 mile accident, something.
Yeah.
And when you think about the way people react to Twitter before they even can confirm anything and how panic stricken they get, can you imagine if you were shorting stocks and did that? And then all of a sudden the stock market's all on Twitter, what? And then you know how it goes. I mean, the automated
it's Black Friday all over again. It's
right.
panic.
Right. And so you could create all sorts of chaos on that. And that was the first time I've really gotten nervous about, oh yeah, that could really be really bad, both from a financial, a physical standpoint, because you don't know how people are going to react and so on and so forth. That was the first time I really got nervous about something.
Tell you the SolarWinds thing is what scared me the most. And I'll tell you why. And as it was happening, I was getting texts from my colleagues who are more on the tech end of it. But it was, I don't mean to sound like I admire these people, but it was brilliant.
Oh yeah.
The hack itself was brilliant.
And it was
you're talking about,
patient.
A supply chain injection. And I was listening to like the pundits online and they're, on their talk shows, and they were going, I don't understand how they just sat in the system for all that time. I'm like, cause that's what they do. Like that happens in most cases. But it was brilliant. And I thought to myself, this has really shown the vulnerability of our supply chain. Mm-hmm. And, all the contracts in the world, don't get me wrong, have a good contract, but are not going to prevent that. But, good cyber practices maybe would have better. And like I said before, this is a shared responsibility model. We all have to be doing our part, because any one weak link and the whole house falls down. Yeah. And that's what we really saw with SolarWinds, was that this one instance caused this chain reaction. Federal government, big companies,
and I think SolarWinds has gotten off way too easy.
Yeah. Well,
they've gotten off way too easy.
We don't even know right now. We are 6 months into this knowing about it, and we're still like, what happened?
Well, and I mean, and we're almost at an hour, so I'm going to be respectful of your time and whatnot. But one other thing, I mean, the FBI just announced the other day that they actually had to hack Microsoft Exchange servers to get out the injections or, the hacks that were done to the security flaws in Exchange to remove those. So the FBI had to hack them and whatnot. So it's, I mean, really, it's a fascinating topic that I could keep talking to you all day about, because we've only touched the surface of sort of what you do and how granular you could go. But like I said, I'm going to reiterate this for folks, is that you need a cyber attorney. It's got to be somebody who is specialized in cyber, because there are so many things going on right now that if they are not, they're going to miss something and they're going to leave you painfully exposed. Well, Rebecca, this was fantastic. You've completed the trilogy, and it's the first trilogy. Okay, it's the best trilogy. I'm not going to do a prequel, and I'm not going to do a sequel to them. I'm going to leave it as is.
I love it.
The three went perfectly, but I really do appreciate it. And you were fantastic, as I knew you would. But everybody should understand, if you do have questions, Rebecca's LinkedIn information, her firm's website is in the episode details below. Feel free to reach out to her because she is a wealth of information. And if your company is looking for some cyber, security from a legal perspective, she wouldn't be a bad person to talk to.
Thank you so much for having me, Sean. This was a lot of fun. I really enjoyed it.
Well, I'm glad you did. And I want to thank all our viewers. You've been watching Did You Know That? ? Remember, new content goes up every Thursday morning. And if you want to be notified of that, be sure to hit the subscribe button. It's somewhere right down there with the bell. And the bell will allow you to be notified when the content does go live. Also, be sure to leave us some positive comments and a like to help the channel. So again, for Rebecca Rakoski, I am Sean O'Rourke. Until next time, you all be well out there in the ether.